Good evening. This is already live from Houston, Texas. Every Tuesday from 5 to 6, Reddy Neumann PC does bring in live from Houston, Texas. Along with me is my business partner, Stephen Brown. Stephen, what do we have today to discuss?
Yeah, absolutely. So we're going to talk, I think the big topic today on all news sites is the midterm elections, but we're going to talk kind of how it's going to impact on the employment-based immigration side. If there's been any regulatory changes by USCIS to benefit H-4 visa holders and the EADs. We're going to talk about the 60-day grace period for H-1Bs and how to calculate that, and then kind of some updates on administrative processing and 221Gs.
Now, what are we expecting in the midterm? Are we expecting a surprise, or it's going to be the same thing as what happened at the time of Clinton time, and then and after that Bush, and then Obama and Trump? Every time in the midterm elections, the opposition party wins. Are we expecting any similar things?
Yeah, I mean, obviously the people that are professionals with elections think that the trends from the last 30 years are going to continue, and whether the Republicans take both chambers of Congress is remains to be seen. But I think it's fair to anticipate at least one of the branches.
So, Stephen, assuming that the houses will be taken over by the Republicans, what are we expecting in there? Is it drastically bad? It's going to be back in Trump era just because the house is taken by the Republicans, or what do you expect?
No, I mean,
I want you to tell in the next 2 months, in the next 2 years, what's going to happen.
Yeah, so let's start the next 2 months. So we'll have a transition period, this lame duck period, where the current leadership will stay in charge, and they could try to do various things to push through the agenda that the Democrats have. Again, assuming the Republicans take over. So, maybe they break the filibuster right now, knowing that it's a little bit safe, because if they do so for the next 2 months to pass things, there's still the Biden administration.
Explain what a lame duck session is.
Yeah. So,
because in most of the countries, once the election happened, that's it, the new parliament comes in. Is it not the same?
No, they're not going to take over. The newly elected folks are not going to take over probably until January, if I remember correct. Mm-hmm. And so that gives us a period here of November through mid-January for them to still push through their agenda. They still operate as the leadership. And so I think what you and I were talking about earlier, the filibuster, especially on the Senate side, that requires 60 votes.
So in other words, even though if the House has been taken by the Republicans, it will still be Congress, a House will be still under the control of the Democrats until second week of January. That's when the House actually changes, though. And a lot of times what happens, especially the small immigration bills, though, gets through in this period of time. Why this lame duck session is very important is now they don't have to face elections for the next 2 years. It's already over. Results are already declared. Now, since they don't have to face the electorate for the next 2 years, now they become very daring in passing the legislation, because if they pass anything, and the negative effect of that might not be there for the long term. People forget it. After 1 year, they forget it. So this is a time where we can expect the lame duck session is where we can expect some changes, especially. What we are advocating at this point of time is to contact the congressman to advocate to pass the EAGLE Act. Now, this EAGLE Act, which is already in the House and has already presented in the Senate, removes the per country limit. It has 4 sponsors, 1 main sponsor and 3 sponsors in Senate, 2 of them being Republicans, 2 of them being Democrats. And also it has 83 co-sponsors in the House. Joe Lofgren from California is the main sponsor for this. So if we get this bill through right now, though, we have a good chance that we're going to be taken off per country limit.
Yeah, I think right now is definitely the time to do it. I mean, either they're leaving the office and they're going to expend their political capital, or they're going to have that free range because they're not up for election anytime soon.
And also, Stephen, what I'm expecting is that Biden is more daring person compared to Obama. Because if you take into consideration of what he did in Afghanistan, we had Obama wanted to pull out of Afghanistan, he didn't. Trump wanted to pull out of Afghanistan, they didn't. Obama had 8 years, Trump had 4 years, they didn't pull it out. When it comes to Biden, he just pulled it out. He didn't care what happened, I am pulling out of Afghanistan. He didn't wait for 2 years to see if there is any change that is going to occur. Now, of course, when it comes to the House and Senate, though, This guy has been in a Senate for a long period of time. He expected the Congress to pass legislation. He tried to do it. Nothing got passed in it. And the things that the budget bill where the immigration provisions were there, they've been kicked out. As you suggested, there is a chance the Democrats might, in this lame duck session, might choose a way to get out of the filibuster and pass all what they want to. Even if they do not, though, I do expect that Biden might be more daring in passing the new regulations or give executive orders. Obama, who was also in favor of immigration, waited for the last 1 year out of this 8 years to make the change, especially when it comes to the DACA people.
Right.
Giving employment authorization to 1 million people. I think so. This is the time for us to advocate the Biden administration. Look, you tried 2 years. These dummies in Congress didn't do anything when your party was in there ruling in the House and in the Senate. They didn't do anything. If they didn't do anything, what do you expect? The House, which is going to be controlled by the Republicans, will help you in doing anything? I don't think so. It's possible. You better be a little bit daring to try to pass the regulations. Maybe not count the family members in the employment-based category. Maybe give some extra benefits for all those people who filed an I-140, whose I-140 is approved, allow them to file the 485 application. There are a couple of other changes that they can do it.
Yeah, I mean, they could go back to the concurrent processing of the H4 EAD. They can, put in things to make processing of the interim benefits for it. I mean, all those are completely don't require Congress at all.
Yeah, that can be done administratively by the administration without going to the Parliament, or what they call here is the Congress. They can do it. So this is the right time for us to advocate to see if any of the legislation can be passed in the next 2 months. And probably if they don't, ask the administration to unilaterally go and change the regulations by not counting the family members, allowing the people to file the 485 application, EAD and advance parole, even if the prior date is not current when the I-140 is approved.
And I do want to address one thing while we're still on this topic, and I know we're not at questions yet, but I see one that I want to address. If the Republicans take over the Senate and the House, I don't think this fundamentally changes immigration at all. It's the Department of State, USCIS still are executive branches, meaning they're still under the president. Maybe things are going to get tougher from bills that are passed, but remember, Biden can still veto, right? He still has that power. And then we're not expecting anybody to be overruling the filibuster anyway. No.
Yeah. So Biden administration, even if they take up the filibuster out, though.
Yeah,
Biden still is the president of the country for the next 2 years and 2 months, so he has a right to veto. So nothing. And he's not against immigrants at this point of time, for sure. He never advocated anything against immigrants, but he didn't do anything. That's a problem. We may be expecting to do, just like the way very drastic action he has taken, no matter what he pulled out of Afghanistan, he needs to do on the immigration, though. He should not do what Obama did it. He should not do what President Bush, who was also very favor of immigration, to wait until to see if the Congress passes anything. Nothing has passed. Obama waited until 7th or 8th year, and then in his 8th year, he issued some executive orders. I think so that Biden administration should start issuing the executive orders and if not, change some of the regulations. Though. Anything else?
No, I think that covers kind of the election. We'll wait to see what comes up tonight.
Now, Stephen, what happened in the H4 EAD? Was there any regulatory changes though? H4 EAD was, we know that according to regulations, H4 and EAD gets approved at the same time. They started working. But what happened? Why is that when the H4 is extended and now you can work for 540 days extra? Is there any regulatory changes or administration unilaterally did? What happened how did this 540 day rule come in?
Yeah, so with the 540 day has come from the 180 day provision that allows for automatic extension.
But there was no 180 days also before.
Yeah, so with litigation that our firm worked with our litigation partners, with Ayla and Jonathan Wasden, we worked together on a case for L2 authorization incident to status, and then these very particular H4 EAD applicants where the H4 has already been extended. USCIS is saying we can't do automatic extensions because the H4 might get denied. But there's people who have H4, whether it's from travel or whatever it might be, that should get the automatic extension. So we were able to get them to create or relook at their interpretation.
And also, please make a note that if you file for a H4 and EAD extension, if the H4 I-94 has expired, you cannot work even under the current rules though. You need to have your H4 extended. There are multiple other ways. If your H4 is not extended, there are ways before your I-94 expires where you can go to Mexico and get your and come back and extend the I-94. We have put a video on it. If you want to, please search for it by 540 days, Reddy Neumann, and you will find that in the YouTube where you can watch the video where you can extend the H4 by 540 day rule, 540 days. And if your EAD is already filed before extension is already filed before your expiry of the EAD, you are automatically extended by 540 day rule. This is a very good thing where people can take it so that there is no interruption of employment. You know, jobs are not there where whenever you want to, you'll get it and hey, my EAD is not there. Can I come back and join 90 days? No, somebody will fill in your position. The employer can't wait. The job can't wait. Somebody may take up the position. They don't want to uproot that guy and give it back to you. So you may want to use this provision of going to Mexico and coming back. Please watch this video called 540 day rule, then you'll understand. And now, Stephen, jobs are becoming a little bit rare now, and we see some layoffs going on though.
Yeah.
What is the 60-day rule that the people who are on H-1B can be unemployed for a period of 60 days and still maintain the status? Can you explain more about it?
Yeah, so just so everybody's aware, the 60-day grace period is a regulatory rule. It's not something that we've made up here, but it also does apply to more than just the H-1B. It applies for TN, E visa holders, L visa holders, and O1 visa holders. And what this is from the date that you have a cessation of employment, and that's the word of art that they use, a termination of employment, you basically are viewed to maintain your status for 60 days. And during that 60 days, you can file to change your status to another non-immigrant status or file for a new employer with your H, your E, your TN, and change employers.
So Stephen, let me ask you this question. Let's say I got terminated on employment on October 10th, okay? And now I am still going to get 10 weeks of pay. So when does the 60-day period start? From October 10th plus 10 weeks or on October 10th?
No, it'll be October 10th. So when your termination happens, not how long you keep
But I'm still getting paid, Stephen.
Yeah, but you're not maintaining your H-1B status because you're not working pursuant to your H-1B.
Okay. And you said it's applicable for E visas, L visas, O visas, and also TN visas.
Yeah, and the dependents too. So if you're dependent on H-4.
So let's say I lose the employment October 10th, okay? And my wife is an H-4 EAD working with, let's say, Apple, okay? Does she need to stop employment on October 10th or she can continue up to 60 days?
She can continue for that 60 days.
And then if I get a job with another company, file a H-1B extension, can she still work because her EAD is with my old company?
No, it's actually not. So the EADs are not tied, H-4 EADs are not tied to the employer. It's tied to you as the H-1B holder maintaining status.
In other words, she can continue working even though I changed the job. Let's say, for example, I changed from Verizon to AT&T. Even though my wife got a H-4 EAD from Verizon, she can continue working for Apple without any interruption,
Absolutely.
Even though her EAD came through Verizon and I got terminated from the employment from Verizon.
Absolutely.
And any other questions before we go to the next topic?
Nope, not on the...
And what's going on this administrative processing, so 221Gs, Stephen? It's been like, I see a lot more people getting issued a 221Gs right now. Even though they're saying it's a Dropbox, a lot more people are getting 221G right now.
Yeah, I think this is the most 221Gs that I've seen in my time of practicing. It's certainly a higher volume. I think there's a lot of things that have happened, and we're also seeing them from people that are doing Dropbox and then getting called for interviews and getting 221Gs. And I think there's a couple of things that are leading to this. Department of State's getting a lot of pressure to hurry up and open up slots for interviews. And I think that in order to slow down the flow with the limited staffing, they're issuing 221Gs to buy themselves some time. And I think that's happening. It's a busy time of the year as well. All the new H-1Bs and all that are trying to get their stamping. So I think they're busy, and then they're trying to slow down the flow.
What's the solution, Stephen? They just issue 221G sometimes. They don't even ask any questions. And no. What is the solution for it?
So we've started doing litigation against these 221Gs. I think in certain situations, that's a good avenue to go, especially the ones, like you said, that they list just administrative processing and they don't provide a reason for it. They should be giving you a reason. A 221G is a refusal. They should be giving you a reason that they're going to refuse it now, and what do they need. So reach out to us. I think in certain circumstances, litigation can be helpful.
Stephen, I'm sometimes very frustrated that when the memo, which requires end client letter, vendor letter, in 1 year, previously we used to get 3 months extension and 6 months extension. Yeah. Now we are getting 3 years extension. Can you explain what happened? Why we are getting 3 years extensions compared to 6 months, 1 year, 3 months sometimes extension? Yeah,
so February 2018, the Trump administration put out a memorandum that a targeted third-party placement, it led to shortened approvals based off of the shortened contractual document that they could be submitted, had an increase of denials based on the project documents we were part of, but ultimately there was a big lawsuit that resolved that because it was counter to the Immigration and Nationality Act and what's required for H-1Bs to require these and to issue these partial denials on based on project documents. The problem, the Department of State's still asking about it.
Yeah. So even though we got resolved in the US, when we go there, they're still asking end client letter, vendor letter, this one, that one, and then issuing the 221G. Is there any, so when you file the lawsuit, what do you tell the court?
Yeah, so it depends on the type of 221Gs, but those that are asking for project documentations, make the reply and then reach back out to us. I think those are good ones because you have Department of State, in my opinion, going further than their authority should be. They should be focusing on admissibility, not eligibility. And when they're asking about these, not only are they getting into eligibility criteria, but they're doing it with something that's already been told by a court is not actually eligibility criteria. So if you get a 221G, get your response in as quickly as you can, and then reach out to us, and I'm happy to talk with you about litigation options potentially for your 221G.
Anything else before we go?
No, let's go to...
the question that is asked by Sachin, which is a very good question. Also, with a new party in majority, would it contribute to USCIS processing delays, though? No, the administration is not changing right now, guys. And this administration, unlike the previous administration, does not want to delay cases. Delay is another way of denying a case. We have seen drastic improvements in the adjustment of status. We have seen a drastic improvement. Even though COVID came in, initially the appointments were very backlogged. They are taking steps right now to eradicate all the appointment delays in the consulates. In fact, what they are encouraging, the State Department recently said that we can make an appointment anywhere in the world, wherever we can get an appointment. For example, in Vietnam, US consulate though, the appointments for the B1, B2 is delayed by 1 day. I don't know how you can make a 1 day appointment. We still need to do biometrics though. And H1B is about 1 week, especially in Chennai and Hyderabad, it's about 700 to 900 days. It's almost 3 years of waiting period. So they're telling you can go to Vietnam and get an appointment there and get the visa stamping and come back. So there are some good contributions that they're doing. There are some drastic changes they are making to make it improvement. In fact, they are now coming up with a policy that they are going to give a green card within 6 months of filing the 485 application. Now I know what you're laughing about. It's at least a better statement.
Agree.
And why are you laughing?
I mean, we haven't seen that, right? I mean, we're still talking about cases that were filed in 2020. I mean, earlier this year, I was talking about cases that were 2012, obviously retrogression there, but I mean, we're still seeing plenty of cases that we're suing on 2020 filings.
One thing is that where we have noticed, Steven, is that The cases that we filed in 2022 got the approval, but the cases we filed in 2020 did not get the approval.
Yeah.
That's where you're suing the USCIS.
Yeah, that's one of them.
Yeah, but they still, when you look into the adjudication of the 280,000 green cards last year, that's definitely they did a good job.
Yeah,
I have to pat on them and say you did a good job on that.
Yeah, I mean, they didn't do any wastage, which we were all worried about. I think the way they went about it was certainly wrong, so I'll give them half kudos for not wasting any, but I'm not thrilled with the way they went about doing it, but it's better than wastage.
Questions from Dr. Krishna Kude. Can I go to Canada to get the 540-day rule? Absolutely. Canada and Mexico are the same thing. The reason why we tell Mexico is one reason is it's a nice country to go. Sometimes you don't need a visa, especially if you have an advanced parole. You don't need a visa to go to Mexico. If you already have a visa stamping in your passport, which is valid, you still don't need a visa to go to Mexico. That's the reason. But yeah, sure, you can go to Canada and come back. The automatic revalidation is still the same thing. You just need to check the visa requirements when you go to Canada.
We have a question from YouTube about change of status for to H4 with the H4 EAD together with the H1, and when is this effective? So you can list the change of status effective date on the I-539. I found out today they don't always follow that. We put sometime in January for someone, but they gave the approval for change of status as of today. You could try a service request on that, but they are not adjudicating them right now with the H-1B. We've heard anecdotally of them getting back to that, but they aren't by policy going back to that completely.
Any benefits of filing, having NIW for an approved regular EB2 I-140 prior date is 2018. Jitin, NIW is going to only give you authority to file a 485 without an employer. So, but with regards to the priority date though, EB2 and NIW are the same. The priority date is still in the EB2. So it doesn't give any specific advantage unless you want to get rid of the company and be on your own independent and don't need any employer to support you to file the 485 application.
Memo asked a question on YouTube. I live in a rural area and drive 35 miles to work from the nearest city. It's a commuting distance for many people. Can I work in the two different cities without a H-1B amendment? I think so. And the Department of Labor language on is an amendment required, or the area of intended employment, right? And what they look at is it within normal commuting distance? And that might be different from one place to another. If it is normal for people in your area to commute that 75 miles, I think that's normal commuting distance. Nothing in the Department of Labor mentions a number other than my example.
Question from Ravi Raja. How risky it is to change employer before entering USA for the first time on H-1B holder? Not that risky at all. If you have a passport stamping, let's say with company A, and now you feel that you have a better offer with company B, absolutely you can. You can file, the company B can file the H-1B, and the good part about Ravi is that you don't have to go for stamping though. Even though you have a stamping with company A, you have a company B H-1B approval though. You can enter into United States with company B's H-1B approval without the passport stamping with the company B's H-1B in there. However though, when you enter into United States, at the time of port of entry, what you need to do is that you need to show them the company B's H-1B approval and request your entry on a company B, not on company A, because it's going to create a problem if you enter without showing them the company B. And make sure you get the I-94 that is valid until the expiration date of what your company B's H-1B is. And as soon as you enter into the country, go online to CBP website, check your I-94. If there is any faults though, it's going to be easy for us to clear it. But if you wait for a long period of time, then it's going to create a lot of problem. So it's better you provide them, look officer, I'm coming on company B's H-1B approval. Here is a company B's H-1B approval, and make sure you go online and check and you're in good shape.
Question from Kumar. I have an I-94 dated August 2023 from employer A and another I-94 dated April 2025 with employer B with concurrent H-1B. With the I-140 being applied through with company A, can I give the I-94 from company A as that you don't want them to know about employer B. You don't have to prove up status with an I-140, do you? Yeah. So, I mean, you can submit to them the I-94. The only time status is going to become an issue is at your 485 stage, not at the I-140.
Did he violate the status?
No, it just sounds like he's got, because of the concurrent H-1B, he's got a second longer one.
Yeah.
USCIS doesn't even know how to do concurrent H-1Bs.
Yeah. And the other thing, what I think so here, Stephen, is that he doesn't want to mention the company
of course.
that is filing the I-140 that he's working for other company.
Yeah.
Absolutely, that's not a problem. And there's another thing though. Look at it. Look at the I-94 number of your primary H-1B application. Look at the I-94 number of the concurrent filed H-1B application. The I-94 number is same. So yeah, I mean, if you don't want to provide the concurrent H-1B to your company that is filing an I-140, absolutely, you're fine. No problem with it. Question with Amog. What's happening with the visa stamping within USA for H-1B holders? It is under consideration, but I don't know how long it's going to take. It's been almost 20 years they removed the system. Now they are telling that they don't have machines to give the visa stampings. They don't have the operational facility to do it. I don't know why they take a long time for them to do it. It can create a lot more employment opportunities in USA if they can give the H-1B stampings here or other visas too, H-4, L-1s and other things too.
Yeah, pre-9/11 it was a thing, but they post 9/11 they were like, we don't have the biometrics capabilities in the U.S. Obviously they do now. I sat in a Department of State roundtable last month. Mm-hmm. They still want to do this. Mm-hmm. It's requiring it's a funding issue. It's an authorization issue. It sounds
it's
like
self-funding.
I know. I don't know if they need additional funding from Congress to get operational. The employees in the U.S.
Our guys will pay extra $100. Make it $200. And they don't want to go to India to get the stamping.
I agree. Yeah, I mean, it's something they want to do, but they haven't done yet.
Okay. Whenever you're on the table, charge them extra $100. Get it done.
I don't think anybody would rather travel. They think they'd rather their visa stamp and pay the extra money now.
Okay.
Question from YouTube. Currently, I'm on STEM OPT, and I applied for my I-485 in October of 2022. Biometrics are done. STEM OPT ends in February of 2023. Can I work on day one CPT as the interim benefits are pending? Our firm does not really like the day one CPT. I think it's potentially a violation of your F1 status, and it could potentially jeopardize your 485. I'm hopeful that applying in October, you'll have your interim benefits, the C9 EAD, and the AP by February of 2023.
Apurv Kumar from Facebook has this question. If we have an appointment with visa stamping in April of 2023, and if we visit US or Canada from US before April, will the automatic revalidation still work? Absolutely, it works. As long as if you're not going stamping, when you make that trip to Mexico or Canada, the automatic revalidation is perfectly all right. Even though you have already booked an appointment in April of 2023, and let's say in January of 2023, you travel to Mexico, automatic revalidation perfectly works. It is not a problem that you have an appointment there.
A question from YouTube. I-140 is approved for the spouse, and she has to apply for the H-1B extension next year. This individual changed from TN to H-1B. Can he do a change of status to H-4 and H-4 EAD and not have a gap in work? You can certainly do it. Whether you'll have a gap in work remains to be seen. I mean, H-4 and H-4 EAD processing times are getting better, but you still may face a gap.
Quan from YouTube has this question. If there is a long employment gap on EAD while on 484 application, will it matter for the final GC approval? It may. There are a lot of arguments in your favor, especially what we can argue is that, let's say the employment gap is longer. Let's say company A, you've been working and you're no longer working for company A. We can make an argument saying that it's not the employment, it is the offer of employment. Company A never withdrew the offer of employment. So even though you're not employed, you are entitled for the green card application. That's one thing. Assuming even if the company has withdrawn the offer of employment, you could be having an employment offer with company B, or you could be having a self-employment offer from your own self, though, which actually, according to the USCIS memo, that is also allowed, that you have an offer of employment for your own self. Now, all these things definitely will be tested. It will be depending on the officer, though. I would say that if there is any employment gap that you are anticipating, and if you are the primary applicant, of course, please contact a lawyer, because all these things, we will keep on arguing, guys. Sometimes we win, sometimes we don't. And here, when there is a gap of employment, especially 1 to 2 years, like the way you mentioned, Mr. Khan, it is definitely is going to be tested. We will make the argument, it will be tested. And you don't want to be guinea pig. I would like to avoid if you can possibly.
Question from YouTube. H-1B was approved in February, however, didn't receive the H-1B approval and filed the I-824. Any idea how long I-824 processing is? It's really long. I think I last looked at it being over 8 months. One thing I would recommend is, think about why you need the approval notice. I think there's some arguments around other alternatives to prove work authorization. And then what I would consider is doing a FOIA so you could get the stamped copy. That should be a lot quicker than the I-824, and do those both in parallel. FOIA, Freedom of Information Act online, to get a copy of the approval notice.
Sri from YouTube has this question. I have to use the Telugu word sometimes. I don't find them in English. Kotta bichaganki doesn't know what time he needs to beg, okay? Sorry. He's asking the question, do we get an I-94 when we travel on green card? No, you don't. You don't. You don't get an I-94, you're fine. However, Sri, though, I want you to note down all your travel dates when you travel outside the country on GST. Why do you need to note down these dates is that when you fill an N400 form, that is for the citizenship application, they ask you, what are the times that you traveled outside the country? What are the times you came inside the country? They do have a record, though. And when we file a freedom of information, we do get the records, though. And it's better that you try to be as accurate as possible. So keep a note on the day you are leaving, on the day you are coming in, so that you can fill the N400. You're right. And you will not get an I-94 if you're traveling on GC. You don't have to look CPP website and go check it out.
Question about being counted against the cap. This individual's with company A for consulate processing. Can you transfer to company B as a cap exempt? And can you file that as a change of status? I think it's really risky. You're not counted against the H-1B cap unless you get the change of status approved, or if you get your H-1B visa stamping. And I think if you try to transfer to company B, you could jeopardize your company A approval if they withdraw it, and company B may, get a denial because you're not counted against the cap. So be very cautious about that.
Question, I'm a green card holder. Can I sponsor my fiance on H-1B? It's a very tricky question. When you say you're going to sponsor a fiance on a H-1B, what do you mean? Your company or what? But in general, though, can a lady come even though she is engaged, to you as a green card holder? Can a person come on a H-1B? Absolutely yes. H-1B is a dual intent visa. Even if the person has an intention to settle in United States, though, they cannot deny the H-1B. Even though they know that she is engaged to you, absolutely H-1 and L-1 are not a problem. Now, it may be a problem for B-1, B-2 or F-1, but definitely not a problem for H-1B.
And on YouTube, I'm on H-1B valid until August 2025. Recently got the GC, EAD, and AP, and my lawyer says there's a gray area whether or not my underlying H-1B status continues if I enter the U.S. using AP. There is a old memo that you can extend your H-1B if you enter in on AP. I agree. It is a little bit of a gray area how you handle that period until you file the extension. Either way, you're protected and authorized to work with the green card EAD.
And we have not seen any problem whatsoever at all in extending the H-1Bs, transferring the companies, extending the H-4s, extending the H-4 EADs. So as Stephen is pointing out, that it is a gray area, but that doesn't mean that they are in EAD.
No.
They should not, and no problem in extending the H-1B.
No, yeah, you could definitely extend the H-1B, and then my position has always been that interim time until that extension is approved, either way you're protected, even if it is a gray area, because you have the work authorization on the EAD.
Does staying unemployed due to the layoffs after getting GC affect naturalization? No, RV, it does not affect though. In fact, you are even eligible for the unemployment benefits though. If you resign, you can't apply for unemployment benefits. Let's say if you're working for Twitter and now, you got laid off with Twitter and you don't have another job, you can apply for unemployment benefits. It is not going to cause any problem for your naturalization or your GC for applying unemployment benefits. So,
question here, lost job on H-1B, filed the change of status to B visa before the end of the 60 days. Now has a job offer, but the lawyer says the H-1B is not portable and I need to exit and enter with a new H-1B. I do agree with this attorney in this position. The 60-day grace period regulations, you can only use it once per approval period. And here you've used it to file your B2 change of status. But what I would probably consider doing is filing the change of status from the pending B2 to H-1B. You can't work anyway until it's approved. If it gets approved, great. If not, you're constantly processing the H-1B. So that's, you're in the same position that you're in right now. So that's kind of how I try to handle those situations.
Josh from YouTube has this question. My company HR reducing my salary by 30,000 less than that is mentioned in the LCA for remote work. Is this legal? Anything less salary than what is prescribed in the LCA is not legal. So I would recommend that either you go personally and work and get the full pay or change the company. Because if you get paid less than the LCA wage, you will be in trouble. Adinath has this question. EB1C went pending and the visa numbers are over in September, as we already know. Now the visa numbers are available. What do I do? Well, if your I140 is approved, since your priority date is current, if your 485 has been pending for more than 365, sue the USCIS. And this guy is the one who does it. How do you do that?
Yeah, we've sued on some of the adjustment of status delays when the green card is current on the final action date. Each set of facts is going to be unique. I think EB1, there's some interesting ways to look at that angle in terms of, you're the first preference category. We can definitely show now that retrogression is not just this theory that immigration lawyers have that isn't real. It happened. It can happen. Now they're talking about retrogression again for the rest of the world. I don't think it'll impact EB1, but
you never know.
You never know. And I never thought that we'd exhaust visa numbers on September 6th in the last fiscal year.
Srinivas PMD has this question. His EAD and AP is approved, but his underlying I-140 denied later on. Will AP and is valid for travel? No. Don't use that advanced parole though. Here is a reason, Srinivas. Once your I-140 has been denied, your 485 should be automatically denied if that I-140 is underlying I-140. Since the I-485 will be denied, your EAD and advanced parole are no longer valid. So I do not want you to travel on the advanced parole.
A question from Sai. I have a H-1B visa appointment coming up. Previous visa rejections. Do you think it'll have issues in your upcoming interview? I think it's really going to depend on what the rejections were for, Sai. A lot of the ones that I see for F1 are immigrant intent. So I don't think that's going to impact you for your H-1B. But if it was something else, let's say it was fraud or something like that, it could definitely impact it. I think you would recommend talking to someone about this, about what your specific ones were before you travel.
Priya from YouTube has an interesting question. Can we sue Congress on immigration for discrimination on Indians? We don't sue Congress though, but we can particularly sue that this particular piece of legislation is unconstitutional. But here is the thing though. Now, there is discriminatory intent and discriminatory effect. Discriminatory intent means when they are passing the legislation, do they have intent to discriminate the Indians at that point of time? Or is it only the effect of it was discriminated? At least on the face of the legislation though, it is not discriminatory intent, but the effect of that is a discriminatory effect of it though. So we have weakness in that. Then there's another thing though, actually when it comes to the immigration, the discrimination based on the national origin may be allowed in the Congress too. So with all due respect, we may lose, very good chances we will lose, because first, it is discriminatory effect, not intent. Second, even if there was an intent, we may lose that case too. There are things that have been tried on diversity legislation though. You need to understand, Priya, that Indians were never been eligible. Mexico nationals were never been eligible for the diversity lottery system. That's only allows, the top 10 countries are not allowed, including Mexico, and India are not allowed though. When they tried it, they failed it. And if you really look into the way the diversity lottery has been made, I mean, they just wanted to benefit one country called Ireland. That's the whole reason they made it. And still we lost the case. So I like it, but I don't think so we have a chance. What do you say about it?
Yeah, we've done some research on this, and if you go look at when the country caps were in 1950, mid the 70s, nobody had Indian nationals on their mind. When this came about, nobody anticipated there would be this kind of retrogression. Like Rahul said, we have what's looking at the intent versus the impact. Theoretically, the UK could be subject to the 7% cap and be backlogged. We see it on the family-based side from Mexico being capped. So unfortunately, I know it has a lot of negative impact on Indian nationals, more so than any other country, but that's never what the intent was. And like Rahul said, unfortunately, there is some allowances for discrimination when it comes to immigration laws.
Can a company file EB1C for an engineering manager position though? Nikhil, it's not about this the position, but it also depends on the amount of people that you're supervising though. The first requirement for EB1C is that you must work for the company outside this country for at least 1 single year before you start working in United States though. That's one requirement. And after that, I normally put a thing like you must be supervising 15 employees. That's where I normally, and they must be direct employees though. For example, we have an office here. We have approximately around 40 people working here, and about 60, 70 people, 40 people working in India, or 60 people working in India. Now we have an accountant. We have only one accountant, and everybody reports to that accountant. But is she a direct supervisor on Stephen? Is she a direct supervisor on me? No. It's just a functional manager though. She's not actually managing us. She's just a accounting. So it becomes weaker if that accountant were to file a EB1C because she's not actually managing them. Now, there are EB1Cs, L1As available for the functional manager too, which we will address it later on. But I normally keep 15 people as the thumbnail before I proceed with the EB1Cs and L1As.
A question from YouTube about the retrogression lawsuits that another law firm is handling and what we think of those. I'm actually working with that law firm on the Texas cases and some of the Nebraska cases. I think the arguments are very solid. It's just a matter of getting the judges to bite off. There's kind of two parts of the Immigration and Nationality Act that are being argued. One says one thing, and historically, I think when you look at how that law was written, really leads in favor of us. USCIS is arguing another provision, and basically, this is how we've always done it, Judge. I definitely wouldn't have worked on these cases if I didn't think they were something that could potentially win. Obviously, I'm not going to put words in their mouth, but I think these are good cases.
Stephen, you keep on saying I do litigation and all those things. Can you give what are the important litigation that you were officially involved in with regards to the business employment?
Yeah, so we had cases on the
you as an official lawyer.
Yeah, me as a lawyer. I'd say we as a firm were involved in some of the February 2018 memo on H-1Bs. We had plenty of cases on those. We are part of the class action cases on the L2 incident to status work authorization. The H4 automatic extension has my name on it.
That's the H4 class action suit.
Yeah, the H4 EAD class action suit as well. And then we've got a number of 485, and again, I say we as a firm, that I've got my 485 delays, 221G delays, interim benefit delays, the EAD and AP for the green cards. We've got a bunch out there that we as a firm have our name on that we've worked on.
Some of them has my name too, but
yes, Rahul's got us in California.
But it's mostly because it's Stephen does work on it, and I get my name there.
Yeah, Rahul is licensed in California, so he makes it a little easier for us to sue out there. What is the process to change status from EAD to H-1B? Again, I'm assuming in this case, Sai, that you've already been counted and had an H-1B before. If that's the case, you would file a change of status from your current status to H-1B. Typical H-1B, it's nothing very unique about it.
Yeah, you just have to go outside the country and get the H-1B stamping. That's all.
Well, if they've had H-1B before, you could do the change of status in the U.S. if they're on like an H-4 EAD.
Yeah. How can we sue USCIS for pending more than 1 year? What's the process involved in it? This question comes from Adinath. Stephen.
Yeah, so 1 year is just kind of a general time frame I look at. We're going to look at a lot of factors before we decide that a 485 case is a good one. 485 litigation is certainly tricky. There's a lot of arguments USCIS likes to make that some courts have been off on. We've developed some strategies around that. Looking at some of the regulations they've put together. So 1 year is kind of my general cutoff that I'll even look at it, and then we're going to look at other factors. How long has it been pending? What are your circumstances? What do you need the green card for? Obviously, green card has a lot of benefits, but maybe there's an age out kid issue or something like that we might want to try to work on. So I think there's a lot of ways to attack it, but like I said, 1 year is just kind of a guideline that I use. I got to give a number to someone. And then we'll look at it from an individual fact basis.
Naresh Metham from Facebook has this question. Is I140 copy is a must to change the employer? Can we use the receipt notice to change the employer? Absolutely. Receipt notice is good. Receipt notice is good enough. Receipt number is good enough. You can go online and print it out actually. And Naresh, I also suggest you that you can actually get an entire I140 copy by filing a Freedom of Information. It takes about 3 to 6 weeks to get it. It's called, please Google this, FOIA, USCIS. And you go to that website and you fill it out. It takes only 10 minutes for you to fill it out. It's free and you don't pay any money, and you get it in 6 weeks by email. And you can use that as an I-140 approval.
And I've done that plenty of times on the H-1B with the receipt notice, so there's no problem there. Swetha asked a question, when there's no lottery, for example, in fiscal year 2020, in 2010, how can we understand if the H-1B was under regular master's cap? So it really shouldn't matter unless you're facing a notice of intent to deny or notice of intent to revoke which cap it was under. You could do a Freedom of Information Act to try to get that file to see what it was filed under, but you still won't know how it was selected under. Ironically, I've read some court cases where USCIS, they don't even know how those cases were selected going back to 2010. That's the one benefit of the online system. Now you know immediately what it was selected under. Even as late as fiscal year 2020, and we didn't know what it was selected under. Now the selection notices specifically mention it.
Krishna has this question. Does B1, B2 tourist visa waiver, he meant to say is Dropbox, not visa waiver though. If it expired, when he said expired, I'm assuming that the visa is expired, the person is in India. Yes, they are eligible for Dropbox right now. Absolutely, they are. Yeah. Next question. To address the issue of the EAD to H1B, there are multiple ways, Sri Krishna. One of the things is that if you, you can always go outside the country and just come back in. If your H1B I-94 is still valid, you can go to Mexico and come back in. That's another easy process for you to do it.
Question, what happens to the I-539 H1 change of status, H1 to H4 plus the I-765 when we travel outside the U.S.? Will it be revoked? What happens? So you do abandon the change of status of the I-539 when you travel outside the U.S. We have found some success with the I-765. What I generally recommend people to do is a two-step process. One, when you enter back in on your H4, file a second I-765 out of abundance of caution, get you in line, and then kind of taking something from the 485 side and interfile your I-765 with an updated status note, with your updated I-94 and your visa stamp, and ask them to attach that to your I-765 file. We have found success in that. It's not a guarantee. That's why I like having that backup I-765. I actually went back and forth with a government attorney on this issue, and we've seen some improvement on this matter, but I would act quickly when this happens because sometimes they will deny the I-765 saying your I-539 was denied, you're not in status.
Retrospect from YouTube has this question. He's wanting to see EB3 or EB2 is better based on the circumstances, bachelor's plus 4 or master's plus 2, depending on what the employer's requirement though. It depends on the employer requirement. I would suggest though, if you are eligible and the position is there for for the EB2, go for EB2. Never go for EB3. The reason is the EB2 can be converted into EB3 without filing another labor certification, but not vice versa. EB3 cannot be converted into EB2 unless you file another PERM application, which is taking, God knows, about 1.5 to 2 years. And that's the reason why EB2 is better. Now, am I telling that EB2 is going to move forward better than EB3? No, I didn't tell that. The only thing I said is that if you file an EB2, you will be eligible for EB3 automatically, but not vice versa. Well, there's another story that comes out, Stephen, delays in the labor certification.
Yeah.
And let's say, for example, I am running out in the 6 years of and PERM is taking a long period of time. Can we sue the Labor Department?
Yeah, no, it's something we're doing the research on, and to get the regulations, you can certainly sue the Department of Labor.
But can employees sue, or it has to be employer? Though?
Yeah, so that's the interesting side of this. PERM's a two-step process. You have the prevailing wage determination and the overall PERM application. I think with the prevailing wage determination, the employer would have to be involved because an individual employee has not been identified. But when we're talking about the PERM application, how it's impacting your 6-year limit, your ability to get EAD, I think you as the individual have some standing there, and I think your employer should tag along if they can, but I think there's a possibility for you as an individual to sue on the PERM application itself. I saw a question I thought it was interesting about the age-out children and H4 EADs for kids. Can we sue? What can be done? This gets back to wanting to push things for Congress. I think that the age-out kids and protecting would have been coined the documented dreamers. It's such low-hanging fruit for Congress that I don't know why they haven't done anything on that. The H4 EAD is a regulatory creation. It's not in the statute like the L2 work authorization. You can't sue saying they're not giving it to kids because USCIS has created this in their discretion and their interpretation of AC 21. Could this be something that letter writing campaigns? I think H4 EAD should be codified personally in the Immigration and Nationality Act, just like L2 work authorization. I think, letter writing campaigns, talking to your Congress folks about H4 getting it statutorily defined and including children, especially those that are over 18 and under 21, and then protecting age-out kids has to be done through Congress, I think.
I disagree with Stephen. Here's the reason though. I want to put everybody in effort to get the family members not counted.
Well, yes.
Because there are some things like all these other sidekicks. Okay, this is not there, but if we get the family members not counted, then we get all the people file the 485 application, at least in the next 1-2 years. So in a way that he's right, Stephen is right, but I want to do effort in my way where I don't want to count the family members. That's the reason we put a draft letter where you can write it to the congressman, you can write it to the administration, you can write it to the USCIS, you can write it to the ombudsman. We put a draft letter. We expect every of you guys to write the letter. Because, Stephen, we can solve the kids also, because in the adjustment of status, the kids are given EAD and AP though. Right. And if the priority date moves, we get the children to be covered under the CSP, Child Service Protection Act. We get all the green card faster. Then we don't need your H4s. We don't need the H4 EADs. What do you say?
Yeah, and I think statistically, right, most of these 485 applications are at least married. So you're almost doubling the number of adjudications that can happen each year if we're not counting
so
spouses.
that will go from 140,000 to 300,000 every year when I look into the stats though.
Right.
So in all the low-hanging fruits of letter writing competition, we feel that this is the most easily achievable thing. Now, Stephen, you said that the H4 EADs are not there in the legislation.
Correct.
So they did issue it for the family members, for the spouse, and they didn't issue it for the kids, and you said you can't sue because it's not there in the Congress. Now, can they not do the same thing? Not count the family members, but the administration can unilaterally do it without going to the Congress?
I think they can. I know there's been plenty of litigation against counting family members, including this summer over an EB5 matter, which ultimately EB5 is similar to EB1, EB2, EB3 when it comes to counting family members. And they lost because it's discretionary, I think, with USCIS to count family members. But I do think they could put forward regulations on that, or executive orders from the Biden administration to not count family members.
All they need to do is look at the same law differently. That's it. Because in the law, it does not say that the family members need to be counted. So it gives up to the discretion of the administration to either count or not count. They don't count the family members when we file the H-1B. Why do they need to count it? So this is the easiest thing without going to Congress. Anything else?
Well, thank you everybody for joining. We have our daily conference call on our website, and you can also set up an appointment at any time with any of our firm's attorneys. We look forward to talking with you guys next week on our weekly Facebook and YouTube Live.
Thank you very much.